You swear that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Do you have any statements you'd like to make?
No, I do not.
Okay. We have, I'm sure, some questions for you. Would you like to start, Senator Blake?
Well, hello, Mr. Clark. Thank you for coming here and for your testimony. I guess I know you don't have a prepared statement, but I guess I would ask you for some perspective on your own experience at the authority and the decisions you faced on the record with respect to these transactions that we've been discussing all day. Could you give us a little historical perspective of your role on the board, the period of time you served, the decisions that you made?
Well, I have to say one thing, that Mr. Pappenfuss is correct in one aspect. We do rely on professionals, lay people. I am not an attorney, I'm not an architect, I'm not an engineer, I'm a public servant. And to that degree, professionals we do rely on, and we trust it. So, as a member of the Harrisburg Authority, I've come to know and come to grow much respect for those people that advise us, who give us their legal, ethical, professional opinion. During the course of the time on the Harrisburg Authority, the transitions surrounding the incinerator are very, very sad. They're sad in the sense that we're here today. And to that degree, I think that what you're doing right now is very, very, very important. And that is trying to get to the truth, trying to find out the facts, trying to create laws and regulations and procedures and policies that help from us getting into the situation that we are in today. So from that degree, I think that today's hearings serve a great public service.
Thank you.
You're welcome.
Mr. Chairman.
Thank you very much, and thank you very much, Mr. Clark, for being here today. On page 19 of the forensic audit, it states, and I quote, "Former Authority Board member Frederick Clark had a conflict of interest arising from his dual roles as an Authority Board member and as an employee of Reynolds. Despite the identification of the conflict, Mr. Clark did not resign from the board, and the Authority awarded contracts directly to Reynolds, and B, with Mr. Clark only abstaining from the votes. What are your comments or explanations for your actions while you were a member of the Harrisburg Authority Board and as an employee of Reynolds Construction?"
That's a very good question, and I appreciate you answering that. A couple things. One is that nobody at any point in time, whole or in part, ever contacted me from the forensic audit. No one. I mean, I'm named in the audit, I'm supposedly I have conflict of interest, but no one called me to find out, and I'm right less than 3 blocks away. That's the first thing. The second thing is this. At the time of this vote, of this procedure, one is that I had voted no. That's on the record. That's a fact. Two, at the time of that vote that you're referring to, I decided, not the attorneys, I decided clearly not only to vote no, but to recuse myself from the vote, as should be reflected in that audit. I don't have it in front of me, or the forensic audit, excuse me, I'm sorry, that I recused myself from it. That's a fact. That's what they found, even though they never spoke with me. Number three is that I read into the minutes, and I don't know if that's reflective in it, but it should be, that I read into the statement of the minutes that this vote is a conflict of interest and that it pertains for me not to vote or cast a vote affirmative, yea or nay. And I did that. Now, what the forensic audit, I believe, and correct me if I'm wrong, states that I should resign from the board. Since that time, I've spoken with a number of attorneys. No one ever suggested, whole or in part, that that would be the right thing to do, the ethical thing to do, or the legal thing to do. At that time, the right thing to do, professional thing to do, the ethical thing to do, the legal thing to do, was to recuse myself and read into the motion, why am I recusing myself? Now, there's another part to it, please, and I won't take too much time. At the time of Reynolds doing business with the authority, I, Fred Clark, have never spoke to one board member, one executive director, not the mayor, not any official, whole or in part, about Reynolds doing business with the authority or Barlow. Never happened, not even with Barlow. There's not one official. I would be happy at any point in time to swear, take a lie detector test to that fact. The other part, I never received one penny, one compensation, no gift, no bonus, no nothing from Reynolds Construction as it relates to them doing business with the authority. There's not one thing remotely close. And I would be happy at any point in time to come back, take a lie detector test, anything you would need to prove that.
Thank you. My next question then, Mr. Clark, is that beginning on page 48 of the forensic audit, it talks about the 2003, quote, city council fund, unquote, and notes Reynolds and you, and it says, quote, Freddie, we're getting paid $1 million and think they can deliver the votes. Would you give us your perspective on both this fund and your involvement in that?
I don't really have any comments as related to the fund. I am, know about I don't have it right in front of me, but I am worried about the one sentence. I think it's Freddie and Reynolds Construction, I never spoke with Mr. House. Mr. House never spoke with me. I chose not to reach out to Mr. House or talk to Mr. House to find out why he said such a thing. I don't even know if Mr. House even said such thing. I don't even know where he got that information from. I never reached out to anyone, whole or in part, to discuss why would you make such a statement. Now, the other part to that is that, if I'm correct, and again, please correct me because I don't have that right in front of me, it's a conversation that's being repeated from Mr. Giorgione in an email to another party. So it's even then, it's third, fourth-hand knowledge, if I'm correct. He's saying that this person said this, and I'm repeating it to another person, I think.
Good.
Yeah.
Well, thank you very much.
You're welcome.
Who did Rhodes and Simon represent in respect to the authority? Because we have, I'll tell you why I asked that. It's because we have a legal opinion here that was dated June 26, 2003, explaining that any member, no member of the authority or officer or employee of the authority may directly or indirectly be a party to or be interested in any contract or agreement with the authority if a contract or agreement establishes liability against the indebtedness of the authority. In other words, the mere fact that an authority member would be connected to a company that would be doing business with the authority would be illegal. And that would be beyond simply an abstention from voting. It would be, in fact, it goes on to explain that it is of note that municipal authorities section is self-executing and any contract or agreement made in violation of the section is void.
I'm not aware of that document, Senator, not at all.
I don't know who.
But I don't know where.
They must have had an outside legal opinion, I assume, at the time.
Yeah, I've never seen it. No, I apologize.
Okay, let me ask you this.
Sure.
I would like to know who was guiding authority members through this quagmire of all this very complicated bonds and financial decisions that were being made. And we've heard a lot of reference today to professionals, calling the shots. What was it like when you were on the ground there, when you were an authority member and things were happening and decisions were being made? Who was really directing things and informing and explaining things to the authority members?
The executive director would make the recommendation to the chairman, and the chairman then would ask for votes upon that recommendation. There would be presentations from the professionals, and those professionals would be Mr. Lipsy, Dan, would be Andy Giorgione, would be Rhodes and Simon, who would be counsel and special counsel. It would be Milt Lopez and his company, who would be bond counsel. It would be the attorneys and the architects and engineers from those entities that were presenting their services to us. So at any given time, on any given issue, you would have 5 or 6 different professionals presenting the rationale as to why the authority should accept the recommendation of the executive director through the chairman of the board. So every time that there was a vote cast, there were absolutely unequivocally professionals there making a case for why and what we're doing.
Did your personal opinion, did you think this was a pretty coordinated effort, or were they just, everybody there was in perfect agreement that everything was okay?
Absolutely.
Forward?
There was no evidence or documentation or information to support contrary to what was being recommended by any of the professionals.
Okay. Mr. Senator Blake?
Again, thank you, Mr. Clark. Two things, and forgive me for not knowing through the date of the period of your service on the board, but one of the big things that jumped out in the forensic audit was the issue of the lack of a performance bond on Barlow. Could you speak to that? Was that in your experience when you were on the board during that period of time? There was a transition between the requirement of a performance bond going into some kind of alternative compensation to protect the authority's interest, and it turned out not to be protection enough. But I wondered if you have any recollection of the decision-making process or whatever process attended the move from requiring a performance bond to waking up and finding out we didn't have one when Barlow went out.
Okay. To answer your first question, at no time, whole or in part, was it ever shared by anyone, directly or indirectly, that what was being presented did not have a performance bond, nor was it asked, nor would it be something that any typical school board member or authority board member or city council, county would ask that type of question. Now, because one would obviously assume that that would be in place. Now, I would most likely think since then, everyone's asking that question before these type of deals. So up to that point, having voted on a number of them, there was no need, reason, expectation to ask that question. And I would only imagine that all those transactions before that activity all had that type of performance bond. City council knew that there was not a performance bond. At least I don't think so. They may not, I'm not quite sure. It was never discussed after all those hearings, months of testimony, before it got to us. I don't think the county commissioners may or may not have known after months of going back and forth as to it. And then it comes to the authority, and we're casting the vote, and the information is presented, and the votes were cast. And it was not asked, and it was not discussed, and it's not something that one would think about asking, hey, by the way, does this have a performance bond?
Understood. Thank you, Mr. Chairman.
Senator Fulmer,
Just one follow-up question. In retrospect, Mr. Clark, do you think you were given adequate information by the authority staff and the professionals to make informed decisions?
I believe that what was presented was, in their opinion, the best course of action. I honestly believe that. I honestly believe that hindsight being what it is, you can look back and Monday morning quarterback, we all can.
Right.
At that point in time, knowing all those individuals, I have no reason to suspect, I have no knowledge, whole or in part, to lead me to believe that the attorneys from either Cled or Eckert or Woody Evans and Woodside or whomever, I don't know those individuals that way, that they would intentionally deceive, corrupt. I don't know, I have no idea about that.
and one last follow-up from me, and that is in respect to that. Were you getting some alternatives? I had asked a question earlier, I don't know that you were here, about, for example, with the guarantee fees that the city and the county were putting on the authorities borrowing, you were getting a better rate because of that, but you also were borrowing a larger sum of money. So was there ever discussions about where are our rates if we don't have guarantees? Can we do it without guarantees? Some competitive quotes on things. Were things like that done for you folks regularly?
I apologize, are you talking about the CIT loan or are you talking about the first one?
Talking really about any loan. Any loan that went through, there were multiple loans where there were guarantees.
Well, I'm going to talk about two that I recall.
Okay.
So let me try to do the first one. The first one, there was never any discussion about that. Basically, the conversation centered around that if we hire this company, who's $40 million cheaper than the other two, that at the end of the day, that we would have an incinerator that is up and running and functional. I believe that that's what they're doing right now. I believe so.
Can I
Go
interrupt
ahead,
on that?
please.
Can you explain that to us a little bit better? Because I've read some conflicting things here about this, about the competitive bids for the project that Barlow ended up doing.
Okay.
How did that work, and what are these other proposals? Were they formal proposals? Was there a formal bidding process? How did that work?
As I recall it, the authority, the board, let's just talk about the board. As it relates to executive director and staff, I have no idea, but I just talk about the board. The board was not involved with the selection, interview, RFP, anything relates to go out and seek and find and bring to us the best person. That just never happened. I believe that was the city's responsibility. And the city did that. They identified Barlow. They bring it back to city council, to the county commissioners, to us, and said, hey, here's who we found. And throughout those discussions, I don't have a piece of paper or a document, but it was disclosed. It was discussed that this one that we're bringing back is the lowest and the cheapest and $40 million cheaper than the next one. And if you said, well, who are the other two, you would have to ask who those people were. So based on that, there was no reason at the time to believe that what they were saying wasn't true, okay? So back to your original question, that talked about the process. That was our involvement in the process, to approve it. To approve it. And that's the way, honestly, and quite frankly, I'm sure people would disagree with me, how much municipalities and school boards and authorities work. You know, you have 3 or 4 or 5 lay people, they work full time, they have jobs. They get off of work, they go to these meetings, and the professionals present what is the best interest of the authority. We think about it, we deliberate it, and we vote on it. That's typically how it happens. So that was the process. Back to answer your question about the first financing. No, there was no discussion as it relates to the approval process and who needed to do what. The second one, however, the CIT, it would be disingenuous of me and untruthful of me not to say and disclose that yes, there was a discussion around that. What would be the process? And basically what had occurred, that it would be legal, ethical, it would have the approval to vote on this without city council's approval. And that there were documents presented that indicated that what we were voting on was okay. So that was the process on the second one. So when you ask the question, was there any discussion about the approvals and on the loans and financing and describing what was the pitfalls? Yes, there was.
So the direction to the authority was generally then coming from the city?
Coming from the city and the professionals, and the authority did take some precautions. I mean, don't want us to make us feel like we're just rubber stamping everything. We asked for other opinions, which we did. For example, the CIT loan, we went back and said, okay, here's what you're saying with your professionals, Barlow. Here's what you're saying, authority, with your professionals. Here's what CIT is saying with their professionals. We want an independent engineer approval finance from a third party, which they provided, that said, if you borrow this money, it will fix the problem and it will be sufficient enough. And we got that, and upon that document, upon that presentation, we voted yes.
Okay. Well, thank you very much. The committee greatly appreciates you being here today.
Thank you. I'd be happy to come back at any time if I can clarify any of my points. Thank you.
Thank you.